for 100 points. Of course, the verdict and the sentence in Charles Taylor was a very important milestone for the Special Court for Sierra Leone. Mr. Taylor being found guilty of all 11 counts of the indictment for planning and aiding and abetting. And the sentence was very important because they gave this man 50 years for planning the most horrific campaign and a horrific campaign of atrocities against civilians, as well as being a critical contributor to the ability of the two major rebel groups to commit these crimes. It was, of course, of historical importance, of legal importance, but most significantly, it was of importance to the people of Sierra Leone because it basically confirmed and affirmed what they told us from the very beginning, that Charles Taylor was among those most responsible for these crimes, and in fact, in the view of many Sierra Leoneans, was the man most responsible for these crimes. So very important achievement there. We also have found over the last year that the legislature in Sierra Leone has ratified the agreement creating the residual special court for Sierra Leone, which will stand up when we close shortly after the appeals judgment in the Charles Taylor case, and that is expected in the last quarter of 2013. We have another significant development over the last year, in that we have 6 persons who have been or are currently subject to contempt proceedings, including the former lead counsel, defense counsel in the Charles Taylor case. That counsel is before a judge for contempt because of violations, alleged violations of protective measures. The others are before the judges for violation of protective measures or attempting to bribe witnesses. This is very important because we need to send a message that witnesses will be free from interference even after the special court closes. And those who interfere with these witnesses will face judicial proceedings before the court. So I believe those are the most significant accomplishments over the last year. Well, I think, first of all, just the conviction of a former head of state for crimes committed by others in another country, which this accused never mentioned during the commission of these crimes. And in relation to the basis for his responsibility in relation to aiding and abetting, I think it has the same consequence as Serge talked about with the Precednt case. They found him to be a significant contributor, substantial contributor to the commission of these crimes through his ongoing aiding and abetting. And I believe that was a very important precedent. Also, as Hassan has mentioned, Mr. Taylor, among other charges, was found guilty of rape and sexual slavery and outrages on personal dignity. Again, these crimes being committed by others, but they were committed with his involvement with the perpetrators, with the awareness that there was this ongoing campaign that included these crimes. So I think that that was also very significant for us. There was another significant part of the case, in that they had to deal again with sexual slavery. And they refined the jurisprudence of the special court in relation to sexual slavery. In an earlier case, the prosecution had alleged forced marriage as one of the forms of sexual violence during the conflict and the associated crimes. And what would happen is they would capture women and girls, they would rape them, multiple rapes at the beginning, and then they would keep them and people would own them. And if you were lucky, you were owned by one person. But when that person no longer wanted you, then you were handed to someone else. And there was a dissent at the trial saying that this was forced marriage. And at the appeal, that dissent was upheld, and so a conviction of forced marriage was entered in that case for the first time. That dissent was upheld on appeal after we had begun in the Taylor trial to present our evidence. So we did not feel we would be able to go back and amend our indictment to include another crime. We proceeded with sexual slavery. And in the judgment against Charles Taylor, the judges again had to look at the jurisprudence now. And they determined that their analysis based on forced marriage was not really the factual characterization of what had happened or the legal characterization, and that what it really amounted to was sexual slavery with an additional component, and that was this forced conjugal association, this forced exclusive ownership that could be passed on. So they found Mr. Taylor guilty of sexual slavery with this component of forced conjugal slavery. So I think that was very important. Well, this is the subject of one of the defense grounds of appeal, so I would need to be very circumspect in my comments, but at the conclusion of the announcement of the unanimous judgment on the merits in Charles Taylor, the alternate judge expressed a personal view that was not, as I understand it, broadcast, but it was captured in draft form in a simultaneous transcription, and my understanding is that the defense basically copied that onto a document and then handed out some copies of that at a press briefing afterward. The alternate judge's personal view was very different than the unanimous decision of the 3 voting judges, and that became a source of much discussion and controversy, and as I said, is the basis for some of the grounds of appeal that the defense are advancing now. So certainly a very unexpected, unusual, and controversial expression of personal view by an alternate judge that the appeals chamber will have to address in deciding the appeal in this case. We are appealing other aspects of the judgment that we felt were controversial. Many people would say you got a 50-year sentence for basically what others characterize as an aiding and abetting case with some planning, and you got a conviction on all 11 counts. So what do you think anything is controversial? And of course, one of the things that we are contesting at the appellate level is their failure to convict Mr. Taylor of ordering, even though throughout the judgment they found he instructed the perpetrators in various ways. They used the language instruction, they used the language imperative, and also talked about his critical role in the ability of the perpetrators to commit the crime. So we will be appealing their finding he did not order, although we will be arguing that the plain language of their judgment in fact established ordering. So that's a bit controversial. But I think in a broader way, the controversial aspect of this case is something that is known to the ICTY certainly, and that is the politicization of the trial, the conviction, and the sentence. And throughout the trial, the argument was that Mr. Taylor was before these judges not for anything he had done wrong, because others had done the same thing, but because he stood up to neo-colonialist Western powers, and that the court, in effect, were simply puppets of the neo-colonialist Western powers, and that was the only reason he was before the court. So this is something that happens often at high levels because they want to deflect attention away from the evidence and the law showing their culpability and put it in a political spectrum where they have been very successful in the past. And this certainly happened in the Taylor trial. And people are often willing to accept those arguments, and there were people willing to accept it in this trial. They continue to accept it today. So I think perhaps that was the most controversial aspect of this case. This is the completion of our judicial mandate, as well as the ability to take all actions that are necessary to transition to the residual court, including our archiving protocol access for the archives. Doing all of that in the face of very significant budgetary challenges, and also looking toward the residual mechanism to ensure that there are adequate mechanisms and funding in place that the court will have the mandate and the ability to continue its obligation to protect witnesses and sources. We can't outsource that, and we need to be able to be sure that we can protect that. Those are the biggest challenges that we are facing.